Peace and love, everyone. Peace and love. Happy Sunday. It is your girl, Empress Marie, back for another video reading. Hope everybody's having a lovely day. The sun is shining bright. So, we're going to be continuing the read. Yeah, she came and got him. We're going to be continuing the read from yesterday from the 0% book. I hope you guys enjoyed yesterday's reading as much as I did. I said I want to finish reading today. Well, not finish, but continue on reading today because I definitely want to know more about what's in this book and the information in it. And I would like to share it with you all as well. So with that being said, I'm going to go ahead and get started. So yesterday we left off on page 38. So we were right here. So I'm going to go ahead and continue on. Okay. So, all right. It says there is no code or statute within any state legislation or United States code book that requires anyone to have a driver's license to operate an automobile, but only for motor vehicles. Most of each state's citizens do not operate. Most Americans have experienced an unfortunate routine traffic stop by a policeman or state trooper and are always required to provide some identification. License and registration, please, quote unquote. Everyone has heard this demand and knows the consequences of providing specific information when asked. So, if there's no lawful driver's license requirement for those an automobile, operating an automobile, then what should one use as the identification along with registration and insurance documents? Many foreign nationals have a way around this, but for now, it is quite simple. If one is not an employed driver, then driving a motor vehicle is false, but instead, more correctly, a traveler traveling public roads and highways. A simple driver ID, a simple travel ID would suffice, such as a valid United States America passport card. Passport card. A passport card is issued to a national of the United States on the same basis as a regular passport. It is valid only for departure from and entry to the United States through the land and seaports of entry between the United States and Mexico, Canada, the Caribbean, and Bermuda. It is not a globally interoperable international travel document. Title 22 CFR 41.39E says passport means a travel document regardless of format issued under the authority of the Secretary of State, attesting to the identity and nationality of the bearer. Title 22 CFR 51.1. So, what should travelers say to any officer when pulled over on the roadside? If one does have a driver's license, it is best to keep it out of the officer's visibility and always have both hands on the steering wheel, displaying a calm demeanor. I'm sorry. Keep in mind the driver's license is a contract which permits the officer to issue an unlawful summons on a public easement. If the officer asks for the license and registration, ask the officer, "Are you seeking to identify my nationality properly, or are you seeking a driver's license required for employees to operate a motor vehicle over 10,000 pounds for commercial purposes. It may be wordy, but it is absolutely what the officer needs to hear from the traveler. The officer may try to pin the traveler into a corner, asking if the traveler is a resident of the state or if the automobile is properly registered with the Department of Motor Vehicles. To further entrap the traveler into the jurisdiction of the state of whatever state ceded to the District of Columbia, the officer will proceed with persistence in obtaining a driver's license. It is up to the traveler to continue to stand their ground and provide the passport card, stating that the passport is valid for land, sea, and air travel. No driver's license is necessary for an automobile, but only for motor vehicles over 10,000 pounds and employees operating on a commercial level. It is highly recommended that all travelers study and be well versed in the subject of their state's constitution, and not just any constitution, but a state constitution before 1933, the year of the United States bankruptcy. For example, if one lives in California state, an authenticated certified copy of the 1849 California's Constitution can be obtained as an arsenal for any court case on the state level. If an officer continues to request a driver's license after the traveler has presented a valid USA passport card during a routine traffic stop, the traveler should state the following: Sir or ma'am, I have provided sufficient identification to a constitutional oath swearing officer. I would respectfully and lawfully request that you provide an affidavit of complaint approved by a judge or clerk of the courts attached to your warrant to stop me and provide a search to my effects. The statement alerts the officer that the traveler knows their God given rights protected by the Constitution and confirms the officer's limits unless the traveler has physically harmed another citizen. Looking at the Declaration of Rights within the California State Constitution, it reads: to the right of the quote unquote people to be sure in their persons, houses, papers, and effects against unreasonable seizures and searches shall be violated, and no warrant shall be issued but on probable cause supported by oath or affirmation, particularly describing the place to be searched and the persons and things to be seized. 1849 California State Constitution, Article 1, Declaration of Rights, Section 19. Notice how Section 19 addresses the subject as the people of California and not the United States citizens or subjects pertaining to the District of Columbia. The people are the Californians, and if referring to the Nevada Constitution, the people are the Nevadans or Oregonians or New Yorkers. According to this law, all officers who swear an oath to the Constitution to uphold the law must have a warrant based on probable cause supported by an approved attached affidavit supported by oath or affirmation from a competent judge or clerk of the court. So, how exactly is a routine traffic stop supposed to work if a traveler has not caused any harm to anyone? Well, simply put, suppose a traveler operating an automobile is speeding and runs a red light without injuring anyone in front of an officer. Constitutionally speaking, the officer is supposed to take down the traveler's license plate, pull the traveler's information from the internal motor vehicle computer system, and begin the process of filing a complaint with the local superior or district court, awaiting approval from the clerk of court or the judge for a certified warrant, which is a summons. This, the sheriff or a deputy within the traveler's county can then properly serve the traveler in person at their abode for a future court date. The law-breaking traveler could then present their case as innocent or guilty in front of their accuser before the court. As mentioned before, foreign nationals have a way around using driver's license or passports. Driver's licenses are valid within the local police department's system, and passports only serve their purpose with state troopers' registry system. So it is wise to understand which form of ID is necessary when dealing with specific law enforcement officers. However, foreign nationals and nationals of the Republic of the United States of America utilize the laws provided in every state country, allowing travelers to use a foreign driver's license without the need of the DMV. For example, in California Code, Vehicle Code, VEH 12505F states, subject to Section 12504, a person over the age of 16 years who is a resident of a foreign jurisdiction other than a state, territory, or possession of the United States, the District of Columbia, the Commonwealth of Puerto Rico, or Canada, having a valid driver's license issued to him or her by any other foreign jurisdiction, may operate a motor vehicle in this state without obtaining a license from the department unless the department determines that the foreign jurisdiction does not meet the licensing standards imposed by this code. In addition to California's foreign driver's license rule, Florida is the same in title, uh, I don't know what that number is, Chapter 322, which reads, a non-resident who is at least 16 years of age and who has his or her immediate possession a valid non-commercial driver's license issued to the non-resident is his or her home state or country operating a motor vehicle of the type or which a Class E driver's license is required in this state. A non-commercial driver's license issued from another county allows for foreign nationals and nationals of America who are foreign to the state. Washington, D.C. falls in line with the Convention on International Road Traffic signed into international law on September 19, 1949. This international treaty regulates automobile traffic, of which the United States of America became a member in 1952. Coupled with the foreign non-commercial driver's license is the International Driving Permit (IDP) issued from the driver's license country. It is valid in over 200 countries, and it obligates the traveler to follow all the traffic laws of the jurisdiction the traveler is operating the automobile. Some laws on the books are not designed for public safety but are mere excuses for the local authorities to check to see if the traveler has all documentation in order. With an IDP, an officer will generally treat the traveler with the utmost respect because the traveler is not in the officer's local computer system to engage in any form of a contract such as a citation or a summons. IDPs can also be used to rent cars and trucks, cash checks, show proof of age, obtain a commercial airline or a cruise ship admission ticket or general ID. It is also in the format of a passport book and must be given to any law enforcement officer with a foreign non commercial driver's license in regards to nationals living in the Republic of the United States of America who have personal effects cars as their everyday means of commuting. The IDP and the foreign non-commercial driver's license must be paired with the registration of the automobile with the DMV, but not in the traveler's name, only in the name of a trust. Suppose the traveler uses an IDP and a foreign non-commercial driver's license with an automobile registered in their personal in legis name with a domestic address. In that case, they are presenting a conflict of law, and the officer will most likely cite the traveler for false identification. Therefore, a trust is a viable solution, registering the automobile in trust without any liens on the property. If there is a lien, it would be wise to utilize the trust to lawfully challenge the creditor, questioning lawful consideration to remove an electronic lien holder with the Department of Motor Vehicles. The title must be in hand in the traveler's name as proof via a bill of sale before the DMV can transfer ownership to the trust. The traveler must use a trust name which presents a significant presence, such as the Morovigian 0101 Trust, and the traveler must operate the automobile at all times as the beneficiary. A public trustee would be the person to register the automobile at the DMV on the behalf of the beneficiary and obtain the trust insurance policy using their domestic driver's license. According to their private contract, the beneficiary would give the trustee the private contract. The beneficiary would give the trustee the money to pay for the premium up front or on monthly installments, declaration of trust, and minutes of meetings. The public trustee would also provide the DMV with IRS Form W-8BN to prevent being obligated to annual registration fees. Like clockwork, the DMV will send the trust its tags and registration without the need for franchise fees or smog checks. A foreign trust is not subject to the taxes owed by a domestic trust. One moment, guys. Sorry about that. Okay. Where was I at? The beneficiary needs to obtain a new name and foreign address listed on the foreign non commercial driver's license. For example, George Stewart, a New Yorker born in Manhattan, New York, could obtain a Panama or South Wales, Australia driver's license along with the country's IDP in the name George Duke or George Bay. This will ensure no cross-referencing of information should be should the officer perform a name search with the DMV database. And lastly, to perfect the foreign non-commercial driver's license with an IDP and trust registration process known as the injunction filing, wealthy families and communities enforce their inalienable God given rights protected by the Bill or Declaration of Rights of the state constitution in the form of an injunction contract with the county sheriff. The injunction is a three-step: first notice, notice to cure, and default notice administration process sent via registered restricted mail to the county sheriff, state chief justice, state attorney general, and the state governor's office. Once all three servings are complete, the traveler can rest assured that they have been manually entered into a state of protection known as the do not detain list for total protection and respect from local law enforcement against victimless crimes in the name of their trust and a foreign new name. The injunction is such a powerful tool that can be used even if the traveler's automobile is not in trust and they choose to list their original state driver's license name on the do not detain list. Regarding voting, the legislative members or qualified electors are the only persons required to select an officer or representative. There is no definition, no U.S. code, or any state code that includes citizens or subjects of the United States to vote for any president or vice president. This is the reason for the existence of the Electoral College. Taking a look at the 1838 Florida Constitution, it reads: No special law shall be passed unless notice of intention to seek enactment thereof has been published in the manner provided by general law. Such notice shall not be necessary when the law, except the provision for referendum, is conditioned to become effective only upon approval by a vote of the electors of the area affected. 1838 Florida Constitution, Article 3 Legislators, Section 10 Special Laws. Qualifications. Each legislator shall be at least 21 years of age, an elector and resident of the district from which elected, and shall have resided in the state for a period of 21 years before the election. 1838 Florida Constitution, Article 3 Legislator, Section 15 Terms and Qualifications of Legislators. The Department of Motor Vehicles has a role to play within voter registration in every state. All states' constitutions provide information about those considered an elector's qualification. Electing high-ranking officials on behalf of the United States citizens and subjects. Even the 14th Amendment that calls the forfeiture of the Moors and other nationalities provides insights on who votes for the president and vice president. As mentioned before, the uncertificated security known as the Social Security number or ITIN is a requirement for the driver's license application. Oh, shoot. All right. Push the wrong button. Okay. All right, here we go. At least for those who have an SSN from the Social Security Administration, which is a requirement to vote, both applications play hand in hand per Title 52 of the United States Code Book, which reads, in general, in general, I, each state, or that's probably one, each state motor vehicle driver's license application, including any renewal application submitted to the appropriate state motor vehicle authority under state law, shall serve as an application for voter registration with respect to elections for federal office unless the applicant fails to sign the voter registration application. An application for voter registration submitted under paragraph 1 shall be considered and as updating any previous voter registration by applicant. C. Forms and procedures. The voter's registration application portion of the application for a state motor vehicle driver's license. C. Shall include a statement that 1. States each eligibility requirement, including citizenship, contains an attestation to the applicant meets each such requirement. And 3. The requirement 3 requires the signature of the applicant under penalty of perjury. Title 15 USC or US Code 20504. Simultaneous application for voter registration and application for motor vehicle driver's license. The applicant's free consent enters one into a special jurisdiction unknowingly unless the law is in its entirety is read and understood. So why exactly do these applications matter a great deal to the legislative officials? And what does the stripping of one's nationality mean? And why are the electors the only ones qualified? Goodness gracious. Okay. I keep pushing the wrong button, guys. I'm sorry. Okay. And why are the electors the only ones qualified to select certain officers and representatives? The answers are ultimately rooted in the 14th Amendment mentioned in the later half of this chapter. Before investigating this amendment, It is important to understand how the Department of Motor Vehicles and voter registration applications work together, determining citizens as debtors. It is accomplished through the Zone Improvement Plan, also known as the zip codes. If one consents to reside in a zip code, which is voluntary, that individual has automatically given jurisdiction to the District of Columbia and its agencies. The use of the zip code is voluntary according to Domestic Mail Services Regulations, Section 122.32. And the United States Postal Service cannot discriminate against the non use of the zip code, according to the Postal Reorganization Act, Public Law 91-375 of August 12, 1970. C. In providing services and in establishing classifications, rates, and fees under this title, the Postal Services shall not accept as specifically authorized in this title, make any undue or unreasonable discrimination among users of the mails, nor shall it grant any undue or unreasonable preferences to any such user. Section 403, page 723. The federal government utilizes the zip code program to validate citizens reside in a federal district of the District of Columbia. The Internal Revenue Service and other similar agencies, state and federal, require a zip code when they assert jurisdiction by sending its alleged citizens an official letter. The United States claims the need for a zip code increases mail delivery speed and efficiency, but of course, this is a deceptive tactic. It is prima facie evidence that the alleged citizen is a citizen of the District of Columbia who is a resident in several states. The term resident is defined as one who has his residence in a place, resident, and inhabitant, and are distinguishable in meaning. The word inhabitant implies a more fixed and permanent abode than does resident, and a resident may not be titled or entitled to all the privileges or subject to all the duties of an inhabitant. Frost versus Brisbane, 19 Wind, New York, 11:32 a.m., December 23. The receiving of mail accompanying a zip code is one of the requirements for the IRS to have jurisdiction to send alleged citizens notices. The government cannot bill a non citizen of the United States or a New Yorker national, for example, because they are not within the purview of the municipal laws of the District of Columbia, meaning the state of New York or the state of Delaware. The Internal Revenue Service has adopted zip code areas as internal revenue districts according to the Federal Register, Volume 51, Number 53. Let me check how y'all doing over here in the chat. Uh, 11:11. I missed it. I really need to go back like 5 videos. So the last video, Cornell Davis, is the beginning of this book. So my video from yesterday is the beginning of this book, actually. So you can start there with this book, but we have other books too that we've been reading. So I still have to finish the other book. But let me go back to reading. I just want to check y'all out in the chat. So it says, under the command of the president to establish and alter internal revenue districts by Section 7621 of the amended and vested in me as a Secretary of the Treasury by Executive Order 10289, approved September 17, 1951, as made applicable to the Internal Revenue Code of 1954 by Executive Order 10574, approved November 5th, 1954, and according to the authority vested in me by Section 321B of the 31 USC and Reorganization Plan Number 1 of 1952 as made applicable to the Internal Revenue Code of 1954 by Section 7804A of such code and by Executive Order 105574. The following internal revenue districts continue as they existed before this order with the changes noted below. 1. Designation of internal revenue districts that comprise an entire state. Alabama headquarters, located in Birmingham, Alabama. Alaska headquarters, located in Anchorage, Alaska. Arizona headquarters, located in Phoenix, Arizona, etc. Federal Registration, Volume 51, Number 53, Wednesday, March 19th, 1986, page 9571. The Postal Service is a private corporation, a quasi-governmental agency. It is no longer a full government agency during the days of the Republic of the United States of America in Congress, assembled in 1787 before becoming a democracy in 1789. It is now like the Federal Reserve System, the Internal Revenue Service, and the United States Marshal Service. They are all outside the federal constitution's restrictions of 1789 as private corporations, or, in other words, a business trust. They are all powerful in their respective areas of responsibility to enforce collection for the federal debt. So, suppose a person uses a zip code. In that case, that person is stating openly and notoriously that the person does not live in the United States. Does not live in Nevada state, for example, but instead is a resident in the state, in the Nevada Internal Revenue District, state of Nevada, of the District of Columbia, a federal district. Many citizens are familiar with addressing their addresses as John Doe with your address 1234 Main Street, Denver, Colorado, with the zip code. This structure notifies the federal government its citizens have yielded to its jurisdiction to adhere to all codes and statutes. The correct form of the same address should be with your surname first, and then your given name, in care of, with your address in those brackets, and then the street. Then put the state in brackets. The city in brackets. Then list your state as a republic, so Colorado Republic, and then put zip code exempt, DMM 122.32, and then put zip codes zeros, all zeros in brackets. This is the form residing outside of the United States. No zip code is needed for accurate delivery. Title 27, the Internal Revenue Code of the United States Code Book, clearly describes how one is held responsible or not held responsible filing for filing a return, which reads: General rule: when not when not otherwise provided for by this title, the Secretary shall, by regulations, prescribe the place for the filing of any return, declaration, statement, or other documents or copies thereof required by this title or by regulations. B. Tax returns. In the case of returns of tax required under the authority of Part 2 of this subchapter, persons other than corporations. A general rule except as provided in subparagraph B. A return other than a corporation return shall be made to the Secretary. In the Internal Revenue District in which is located the legal residence or principal place of business of the person making the return, or 2. A service center serving the Internal Revenue District referred to in Clause 1 as a secretary may by regulations designate. B. Exceptions returns of 1. Persons who have no legal residence or principal place of business in any Internal Revenue District. 2. Citizens of the United States whose principal place of abode for the period with respect to which the return is filed is outside the United States. Title 26 U.S. Code 6091. Place for filing returns or other documents. It should be notated from Section B, exception returns. Any person or business not listed within any internal revenue district or any citizen whose primary place of living is outside the United States are not subjected to filing a return to the IRS, but where exactly is the United States located? It's no doubt a federal corporation, but where is its principal place of business? Many people and their families live in residential homes, multi-family tracts, apartments, condominiums, mobile homes, and businesses in several business center tracts within the 50 nation countries that became a confederation. They would automatically think that their abode or place of business qualifies as being within the United States. In all actuality, the United States after 1789 is not the 50 nation states of the United States of America. By using the zip code classification, the alleged citizen falls in line with Article 9, Secure Transactions of the Uniform Commercial Code, as not being a creditor with a nation but instead a stateless debtor, which reads Location of debtor. A. Place of business. In this section, place of business means a place where a debtor conducts its affairs. B. Debtor's location. General rules. Except as otherwise provided in this section, the following rules determine a debtor's location. 1. A debtor who is an individual is located at the individual's principal residence. 2. A debtor that is an organization and has only one place of business is located at its place of business. 3. A debtor that is an organization and has more than one place of business is located at its chief executive officer. C. Limitations of applicability of subsection B. Subsection B applies only if a debtor's residence, place of business, or chief executive office, as applicable, is located in a jurisdiction whose law generally requires information concerning the existence of a non-possessory security interest to be made generally available in a filing, recording, or registration system as a condition or result of the security interest obtaining priority over the rights of a lien creditor with respect to the collateral. If Subject B does not apply, the debtor is located in the District of Columbia. H. Location of the United States. The United States is located in the District of Columbia. UCC 9-307, location of debtor. The United States is located in the District of Columbia. Let that sink in once more. The United States is located in the District of Columbia, and it has internal revenue districts in all of the 50 states as private corporations. If one consents to reside in any of the 50 states, federal districts, that person is liable for submitting tax returns to the Secretary of the IRS. Another viable question is, how exactly did all the states become a part of the District of Columbia? After all, the 50 states existed within the United States of America's Constitution in 1787 before the new 1789 Constitution, leading to the Organic Act of 1871, establishing Washington, D.C. Article 1 of the United States Constitution reveals the answers. It reads, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may by session of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislator of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyard, and other needful buildings. The Constitution of the United States, Article 1, Section 8, Clause 17. The key word in this section of the Constitution is cession. Each state has voluntarily participated in cession, meaning the formal giving up of rights, property, and territory by a state, giving jurisdiction over to the District of Columbia. For example, the evidence in the preamble of the Tennessee Constitution of 1796, we the people of the territory of the United States south of the river Ohio, having the right of admission into the general government as a member state thereof, consistent with the Constitution of the United States and the Act of Cession of the State of North Carolina, recognizing the ordinance for the government of the territory of the United States northwest of the river Ohio, do ordain and establish the following Constitution or form of government, and do mutually agree with each other to form ourselves into a free and independent state by the name of the state of Tennessee. By cession, that the Republic Tennessee state became the Democratic State of Tennessee Federal District, or the Republic California state became the Democratic State of California Federal District. All of the 50 states have become a part of the state of ceded to the District of Columbia, which is why the 14th Amendment states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Constitution of United States of America, 1789, 14th Amendment, Section 1. The 14th Amendment was ratified in 1868, and when it mentions the United States, it refers to the 10 square mile District of Columbia. Suppose one is identified as a U.S. citizen, a state citizen, a U.S. national, a legal permanent resident, or state resident authorized by the 14th Amendment. In that case, such a one is liable for taxes, licenses, real IDs, state permits, and licenses. The following questions were asked in this chapter. What is the origin of the Fourth Amendment? What type of person does it create? A citizen or a subject? What does it allow a person to do or not to do? After all, isn't it an honor to be a United States citizen? Hell to the no. No, it is not an honor. And anyone who thinks it is, they're fools. They're absolute fools. And I know a lot of them. So we're moving on to chapter 2, which talks about the Fourth Amendment citizen, okay? All the fools that think they're powerful. The 14th Amendment was officially ratified on July 9, 1868, granting citizenship to everyone born or naturalized in the United States, which included alleged slaves, or did it? By directly mentioning the state's role, the 14th Amendment greatly expanded civil rights protections to all Americans and is cited in countless litigation cases than any other amendment. It's interesting to read that the 14th Amendment is the most cited litigation over any amendment to the Constitution. President Donald Trump spoke heavily about the removal of the amendment. Why is that? Could the 14th Amendment be illegal, fraudulent, and cause restrictions, or all the above? Reading each section of the 14th Amendment in its entirety for a complete understanding is paramount. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. 1789 U.S. Constitution, 14th Amendment, Section 1. Notice how the first sentence uses keywords such as born, naturalized, the United States and the jurisdiction thereof. Again, the United States is a federal corporation which, located in the District of Columbia, looking at the word born and the definition of naturalized, it means to confer citizenship upon an alien, to make a foreigner the same in respect to the rights and privileges as if he or she were a native citizen or subject per Black's Law Dictionary, second edition. It would raise the question of how can someone be born into a fictitious federal corporation, knowing the United States is in the District of Columbia and one is naturally born in one of the 50 countries or states. Just from the first sentence, the 14th Amendment does not make any lawful sense. Another fact to observe in the word all persons exactly is the amendment referring to. Let me read that again. Another fact to observe is the word all persons. Exactly whom is the amendment referring to? It is an artificial person, defined as it is a non-human entity created by law and is legally different from owning its rights and duties, also known as a juristic person and legal person, refer to the body corporate. Black's Law Dictionary, the second edition, artificial person. A similar word is a juridical person, defined as an entity, as a firm that is not a single natural person, as a human being authorized by law with duties and rights, recognized as a legal authority, having a distinct identity, a legal personality. Also known as an artificial person, juridical entity, juristic person or legal person. Also refer to a body corporate. Black's Law Dictionary, second edition, juridical person. The 14th Amendment is referring to a legally generated juridical person or fictitious artificial person. According to Black's Law Dictionary, second edition, a natural born person is a human being, naturally born, versus a legally generated juridical person. An artificial person is created in the United States and subjected to its jurisdiction thereof and initially created through the certificate of live birth by an elected official within the county government. This official is the registrar, recorder, county clerk. The second part of the section 1 explains. No state shall make or enforce any law which shall abridge the I don't know why I keep wanting to say abridge the privileges or immunities of citizens in the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. All states that ceded their power over to the District of Columbia so that no state can make any law against Washington, D.C.'s alleged citizens. The only rules that govern the alleged citizens are any state constitution after 1933 and any code after the ratification of the 14th Amendment. This is precisely where the District of Columbia wants their alleged citizens' rights and privileges to be derived. The second section of the 14th Amendment dives more into the election process, which reads, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at the election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislative thereof is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear the whole number of male citizens 21 years of age in such state. 1789 U.S. Constitution, 14th Amendment, Section 2. Notice how several states is used with a capital S and not a lower s, referring to the federal districts and not the several national country states from the Republic United States of America, 1787. Section 2 mentions the representatives, who are an entirely different group of individuals compared to the male inhabitants or U.S. citizens over the age of 21. The electors, the president or vice president, and Congress members, including the legislators. The specific groups of representatives are whom we, the people, select within local government. For example, in Riverside County of California, the Riverside County Organization Chart lists several departments and positions that run the county. Jobs such as County Executive Officer, County Council, Public Social Services, Economic Development Agency, Public Health or Assistant CEO, RUSE, Health and Hospital Services. These are the positions that the people select to run their local government, and from these selected positions, they choose the principal electors, such as the sheriff. The final electors have the opportunity to vote and elect the president and Congress members on behalf of the people. Bouvier's Law Dictionary, 1856, edition defines electors of president as persons elected by the people whose sole duty is to elect a president and vice president of the United States. Only a select few officials hold the elector's title within Riverside County, California, such as sheriff, coroner, district attorney, assessor clerk, auditor, controller, treasurer, tax collector. It is true, citizens choose to submit ballot tickets that allow them to place their votes for the sheriff, assessor, and others. Still, the real matter of concern is how exactly are the people's ballots considered per the 14th Amendment's voting procedure. The amendment states that the representatives shall be apportioned according to their respective numbers, counting the whole number of male inhabitants, excluding Indians who are not taxed. Remember that the Indians derive their name as an employee of the Dutch East or West Indian Trading Company. Therefore, an Indian employee was not taxed by its third-party employer, the U.S., solely, owing allegiance to the trading company. When the right to vote for the representative for the choice of electors for the president and the like is denied to any male inhabitant or citizen of the United States being over the age of 21, the whole number of representatives shall be reduced according to the whole number of male inhabitants or citizens of the United States over the age of 21, except when a male inhabitant or citizen of the United States over the age of 21 has participated in rebellion or committed a crime. Then the representative respective numbers shall usurp the whole number of male inhabitants or citizens of the United States over the age of 21. Many citizens of the United States would claim that they have not committed any crimes or engaged in any form of rebellion against the United States and should meet the requirement of having the right to vote for a representative for the choice of electors for the president and the like, let alone choose the president themselves if they could. It is essential to understand that after 1789 and under the Organic Act of 1871, the United States is located in D.C. and is not a country. It is a federal corporation consisting of presidents, chief executives, chief financial officers, chairmen, and secretaries. Countries have kings, queens, princes, grand dukes, emperors, Caesars, khans, sultans, and others. Therefore, a corporation is never to rely on the public to elect its president or chairmen. It would indeed be the responsibility of those who hold the highest number of shares in the company's certificates It is beginning to make sense as to why has why this amendment has been the most talked about amendment within every United States court. If male inhabitants or citizens of the United States over the age of 21 participate in rebellion or commit crimes against the United States, their right to vote, abridged, would be forfeited against the number of representatives within the local government. It would be their whole number to exceed the entire amount of people they represent. How is this possible? What crime could have been committed unknowingly by the citizen of the United States? The answer has always been in plain sight, especially to the United States or the U.S. citizens who travel the world. To move across the earth, one must apply for a United States of America passport. The actual application allows each applicant to voluntarily state that he or she is a criminal or not from the use of federal and state forms. The United States federal government can reduce the number of male inhabitants or citizens of the United States over the age of 21 against the representatives for electors' choice. Mostly, all Americans are familiar with the DS-11 passport application. Jumping to page 4 and focusing on the section titled Acts or Conditions, federal government, in their crafty ways, has deemed U.S. citizens to be criminals and rebel against the United States if they are not careful in comprehending instructions. It reads, if any of the below mentioned acts or conditions have been performed by or applied to the applicant, the portion which applies should be lined out, and a supplementary explanatory statement under oath or affirmation by the applicant should be attached and made a part of this application. So when you submit your application, you need a supplementary explanatory statement, okay, under oath or affirmation. With full comprehension of the first sentence regarding instructions, how many Americans have drawn a line through select wording in the acts or conditions portion of the application and provided a supplementary statement in the form of an affidavit? It clearly says the part which applies should be lined out on the actual application. Everyone has been taught to cross out or line out sections where it does not apply. But here within the DS-11 passport application, it is the opposite. The next sentence reads, I have not, since acquiring United States citizenship or nationality, been naturalized as a citizen of a foreign state, taken an oath or made an affirmation or other formal declaration of allegiance to a foreign state, entered or served in an armed forces of a foreign state, accepted or performed the duties of an office, post, or employment under the government of a foreign state or political division thereof, made a formal renunciation of nationality either in the United States or before a diplomatic or consular officer of the United States in a foreign state, or been convicted by a court or a court martial of competent jurisdiction of committing any act of treason against or attempting by force to overthrow or bearing arms against the United States, or conspiring to overthrow, put down, or destroy by force the government of the United States. Furthermore, I have not been convicted of a federal or state drug offense or convicted of a sex tourism crimes statute, and I am not the subject of an outstanding federal, state, or local warrants of arrest for a felony, a criminal court order forbidding my departure from the United States, a subpoena received from the United States in matter involving federal prosecution for grand jury investigation of a felony. It's fascinating to see what Americans sign before understanding word for word and how it applies to them. This is one of the many tactics the federal government entraps the people into voluntary participation in rebellion, which is considered a criminal offense. If one wanted to submit a correct DS-11 passport application, which information on how to complete an explanatory statement. It is thoroughly detailed in the nationality chapter of this book. Okay, so we'll eventually get to that. The following is how to line out the portion which applies to the applicant of a non-criminal. I have taken an oath, made an affirmation, formal declaration of allegiance to a foreign state, made a formal renunciation of nationality in the United States. Furthermore, I have not been convicted of a federal or state drug offense or convicted of a sex tourism crime statute, and I am not the subject of an outstanding federal, state, or local warrant of arrest for a felony, a criminal court or order forbidding my departure from the United States, a subpoena received from the United States in a matter involving federal prosecution for or grand jury investigation of felony. Simply line out the applicable words in the acts or conditions section of the DS-11 passport application. By doing this, Americans have just prevented themselves from allegedly participating in rebellion or openly admitting to a federal or state criminal offense, which is on record with the Department of State that can be obtained as a Freedom of Information Act request. Continuing with Section 3 of the 14th Amendment reads, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who have previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislator, or as an executive or judicial officer of any state that support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may vote by a vote of 2/3 of each house, remove such disability. 1789 U.S. Constitution, 4th Amendment, Section 3. Section 3 gives more of a precise description that no 14th Amendment citizen, by way of Section 1, can be a senator, representative of Congress, or more importantly, an elector of the president or vice president. Senators, representatives of Congress, executive, judicial, or legislative officers or electors are not U.S. citizens or U.S. nationals. They hold a higher lawful status than the legal status of a citizen of the United States. They are nationals but not a U.S. citizen per Public Law 94-241, March 24th, 1976. Nationals are the people. U.S. citizens do not select the United States presidents or vice presidents. Their ballots are simply surveys informing the corporate leaders of the whereabouts of the people's opinions on public political topics. Once again, it is the people, nationals, who select their representatives within local government, who then choose county electors, who then elect the senators, representatives in Congress, and the presidents or vice presidents. According to the Section 4 of the amendment, the validity of the public debt of the United States authorized by public law, including debts incurred for payment of pensions and bounties for services in suppressing insurrections or rebellion, should be or should not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. 1789 U.S. Constitution, 14th Amendment, Section 4. A community referred to as the Secured Party Creditor Movement or the Patriot Movement claims that there is no lawful money since 1933. The basis of this observation comes from the federal government demanding all citizens to turn in their precious metals in exchange for paper fiat currency. In fact, There is lawful money, and debts can be questioned for discharge, but it must be done through a particular vehicle known as a trust as a natural person. The federal government left the choice up to the people to have lawful money. They either expand the national public debt using fiat currency or utilize private treasury notes, which cancels interest. Furthermore, Section 4 states that no U.S. citizen, naturalized citizen, or legal permanent resident can question the public debt by way of the 14th Amendment. And sadly, this section just admitted that a 14th Amendment citizen is likened to an emancipated slave, just like the Anglo Saxon slaves under the British Moors of Great Britain were freed by the Declaration of Independence of 1776. The word emancipation comes from the Latin word emancipatio, which means a certain ceremony or a formal process anciently required to be performed to perfect the sale or conveyance of res mancipi, land, houses, slaves, horses, or cattle. The parties were present, vendor and vendee, with 5 witnesses and a person called librepens or liberpens, who held a balance or scale, a set form of words repeated on either side, indicative of transfer of ownership, and certain prescribed gestures performed. And the vendee then struck the scales with a piece of copper, thereby symbolizing the payment or weighing out of the stipulated price. Black's Law Dictionary, 2nd edition. To be emancipated is to transfer ownership of a property from one owner to another. Slaves of the Atlantic slave trade were transferred from involuntary servitude of penal colonies or debtor prisons and an old form of slavery into a new tax-based voluntary servitude form of slavery controlled by the District of Columbia. People today are not transferred from one owner to another. They have voluntarily surrendered their God given birthrights as a national, but not a citizen of the United States, over to the District of Columbia's jurisdiction by way of the 14th Amendment contract. Section 4 is why not every Section 4 is why not everyone can use House Joint Resolution 192 to discharge the public debt. If one is a 14th Amendment citizen attempting to offset public debt liability, it will not work unless a trust is used, as previously said. Okay, y'all hearing this? The Congress. So this is why they say like the A4V process when we sending in accepted for value and putting the HJ House Joint Resolution information on our paperwork and sending it in, thinking that our bills are going to get paid. This is why it's not getting paid or it's not working because, like it simply says, we're still 14th Amendment citizens. We're still in that contract, okay? The last section of the 14th Amendment states the Congress shall have the power to enforce by appropriate legislation the provisions of this article, 1789 U.S. Constitution, 14th Amendment, Section 5. Section 5 gives the federal government the right to create any law which controls every 14th Amendment citizen, even though every state's constitution says no bill of attainder, ex post facto law, or law impairing the obligation of contracts shall ever be passed. No law such as the entire 14th Amendment shall usurp the state constitutional law. However, it is an individual's voluntary consent to surrender to the several 14th Amendment contracts via Social Security forms, driver's license or state ID applications, insurance forms, passport applications, and voter registration forms. All of the above applications allow Congress to have the power to enforce any corporate code or statute over the corporate juridical person. Who are the juridical persons exactly? Unfortunately, the people of this beautiful land hold identification as U.S. citizens, U.S. nationals, state citizens, residents, or legal permanent residents. It is the corporate name listed in their system in all capital letters, such as your first, middle, and last name. This, in all caps, this classification system is an ancient Roman law system known as Capitis Diminutio law. I'm sorry if I pronounced that incorrectly, which diminishes a person's personality or status. A person may lose his nature or legal capacity either in whole or in part. There are three states of losing a person's personality. The first, capitis diminu, I can't say that word, y'all. Minima, consisting of losing someone's family relationship. The right to liberty is unaltered in this stage. There is only a minimum loss of status. The second, capitis diminutio media, uh, includes losing one's citizenship and their family name. In capitis diminutio minima, there is a medium loss of status. The third is capitis diminutio maxima, consisting of the deprivation of freedom, citizenship, and family name. In this stage, a person's status is changed from freedom to bondage. This is the highest status loss. This is the status of all citizens, U.S. nationals, state citizens, residents, and legal permanent residents, and to correct it, it must be done on every level of government, beginning at the Department of State with the passport application, followed by the Social Security Administration, then the Department of Motor Vehicles. Each inhabitant's status should be a national but not citizen of the United States, which is naturally a creditor. The 14th Amendment's real motive comes from the words of Senator Benjamin R. Pitchfork Ben Tillman. On March 23, 1900, a speech was given before the U.S. Senate. Senator Benjamin R. Pitchfork Ben Tillman of South Carolina defended his white constituents' actions who had murdered several black citizens of his home state. Tillman blamed the violence on the hot-headedness of Southern blacks and this misguided effort of Republicans during the Reconstruction era after the Civil War to put white necks under black heels. Mm. He also defended violence against black men, claiming that Southern whites will not submit to the black man, gratifying his lust on our wives and daughters without lynching him and evocation of the deeply sexualized racist fantasies of many whites. Mm, he quotes. Wow. And he, Senator John C. Spooner of Wisconsin, said we had taken their rights away from them. He asked me, was it right to murder them in order to carry the elections? I never saw one murdered. I never saw one shot at the election. It was the riots before the elections pre- uh, precipitated by their own headedness and in attempting to hold the government that brought on conflicts between the races and caused the shotgun to be used. This is what I meant by saying we used the shotgun. I want to call the senator's attention to one fact. He said that the Republican Party gave the Negroes the ballot in order to protect themselves against the indignities and wrongs that were attempted to be heaped upon them by the enactment of the Black Code. I say it was because the Republicans of that day, led by Thad Stevens, wanted to put white necks under black heels and to get revenge. There is a difference of opinion. You have your opinion about it and I have mine, and we can never agree. I want to ask the senator this proposition in arithmetic. In my state, there were 135,000 Negro voters or Negroes of voting age, and some 90,000 or 95,000 white voters. Wow. Generally can be set up by a carpetbag government there and turned our state over to this majority. Now, I want to ask you, with a free vote and fair count, how are you going to beat 135 by 9,500? 95,000. Wow. Wow. How are you going to do it? You had, I'm sorry, you guys. Oh, goodness. Okay. You had handcuffed us thrown away the key, and you propped your carpet bag Negro government and bayonets. When it was necessary to sustain the government, you held it up by the army. Mr. President, I have not the facts and figures here, but I want the country to get the full view of the southern side of this question and the justification for anything we did. We were sorry we had the necessity forced upon us, but we could not help it. And as white men, we were not sorry for it, and we do not propose to apologize for anything we have done in connection with it. We took the government away from them in 1876. We did take it. If no other senator has come here previous to this time, who would acknowledge it? More is the pity. We have had no fraud in our elections in Southern California in 1884. There has been no organized Republican Party in the state. We did not disfranchise the Negroes until 1895. Then we had a constitutional convention, which took the matter up calmly, deliberately, and avowedly with the purpose of disfranchising as many of them as we could under the 14th and 15th Amendments. We adopted the educational qualification as the only means left to us, and the Negro is as contented and prosperous and as well protected in South Carolina today as in any state of the Union south of the Potomac. He is not meddling with politics, for he found that the more he meddled with them, the worse he got. As to his rights, I will not discuss them now. We of the South have never recognized the right of the Negro to govern white men and never will. Wow. We have never believed him to be equal to the white man, and we will not submit to his gratifying his lust of our wives and daughters without lynching him. Wow. I would be God. I would to God the last one of them was in Africa, and that none of them had ever been brought to our shores. But I will not pursue the subject further. I want to ask permission in this connection to print a speech which I made in the Constitutional Convention of South Carolina when it convened in 1895, in which the whole carpetbag regime and the indignities and wrongs heaped upon our people, the robberies which we suffered, and all the facts and figures there brought out are incorporated. And let the whole of the facts go to the country. I am not ashamed to have those facts go to the country. They are our justification for the present situation in our state. If I can get it, I should like that permission. Otherwise, I shall be forced to bring that speech here and read it when I can put my hand on it. I will then leave this matter and let the dead past bury its dead. Speech of Senator Benjamin R. Tillman, March 23rd, 1900. Congressional Record. 56 Congress, First Session, 3023 to 3224. Uh, from the South Carolina, from the South Carolinian senator, it is straightforward that the government in South Carolina and all southern states were governed by the Moors, swarthy and tawny men. They had voting rights and outnumbered the white Anglo-Saxon voters 135,000 to 95,000. The senator understood very well to make it a difference. A constitutional convention would need to be disenfranchised would need to disenfranchise the Moors, meaning to deprive one's rights to vote and strip them of their nationality into the jurisdiction of the 14th Amendment. Several important questions arise from reading the senator's speech. He mentioned they took the government away from the Moors, who held title of nobility in 1876, and they did not disenfranchise the Moors until 1895. The most obvious question is, how is it possible? Moors, black men, controlled all government until 1895, and why would white men be concerned with depriving their right to vote if they were enslaved and freed 30 years before abolishment in 1865? This is one of the many pieces of the puzzle the federal government did not expect the American people to uncover. Yet again, the federal government is found guilty in a deceptive detour of reconstructive history. It is undoubtedly impossible that in just 30 years, uneducated African slaves who were brought to the 13 colonies could receive their freedom in 1865 and immediately run all of the southern states as a Republican government to lose it in 1867. Okay, that's it. It is undoubtedly impossible. Okay. The 90th Congress of 1967 would also agree about the Moors' position. Their government and their power within the Confederate United States of America Corporation, per the United States of America Congressional Record, Volume 113, Part 12 of June 12, 1967 to June 20 of 1967. 3. Proposed amendment never ratified by three-fourths of the state. 1. Pretending the effectiveness of said resolution as above, 15 states out of the then 37 states of the Union rejected the proposed 14th Amendment between the date of its submission to the states by the Secretary of State on June 16, 1866 and March 24, 1868, thereby further nullifying said resolution and making it impossible for its ratification by the constitutionally required three-fourths of such states, as shown by the rejection thereof by the legislators of the following states. Texas rejected the 14th Amendment on October 27, 1866. Georgia rejected the 14th Amendment on November 9, 1866. Florida rejected on December 6, 1866. Alabama, December 7, 1866. North Carolina on December 14, 1866. Arkansas, December 17, 1866. South Carolina, December 20, 1866. Kentucky, January 8, 1867. And Virginia, January 9, 1867. Louisiana, February 6, 1867. Delaware rejected the 14th Amendment on February 7. Maryland, March 27, 1867. Mississippi rejected January 31st, 1867. Ohio was in January 15th, 1868. New Jersey rejected on March 24th, 1868. Congressional Record, Volume 113, Part 12, June 13, 1967, page 15, 642. There was no question that all the southern states which rejected the 14th Amendment had legally constituted government, were fully recognized by the federal government, and were functioning as member states of the Union at the time of their rejection. 5. Faced with the positive failure of ratification of the 14th Amendment, both houses of Congress passed over the veto of the President 3 acts known as Reconstruction Acts between the dates of March 2nd and July 19th of 1867, especially the third of said acts. 15 stat page 14, etc., designed illegally to remove with military force the lawfully constituted state legislators of the 10 southern states of Virginia, North Carolina, South Carolina, Georgia, Florida, Alabama, Mississippi, Arkansas, Louisiana, and Texas. In President Andrew Johnson's veto message on the Reconstruction Act of March 2nd, 1867, he pointed out these unconstitutionalities. Quote, in all these states, there are existing constitutions framed in the accustomed way by the people. Congress, however, declares that these constitutions are not loyal and republican and requires the people to form them anew. What then, in the opinion of Congress, is necessary to make the Constitution of a state loyal and republican? The original act answers the question. It is universal Negro suffrage, a question which the federal Constitution leaves exclusively to the states themselves. All this legislative machinery of martial law, military coercion, and political disfranchisement is avowedly for that purpose and none other. The existing constitutions of the 10 states conform to the acknowledged standards of loyalty and republicanism. Indeed, if there are degrees in republican forms of government, their constitutions are more republican now than when the states, four of which were members of the original 13, first became members of the Union. Congressional Record, Volume 113, Part 12, June 13, 1967, page 15,643. From all the above documented historic facts, it is inescapable that the 14th Amendment never was validly adopted as an article of the Constitution, that it has no legal effect, and it should be declared by the courts to be unconstitutional and therefore null and void and of no effect. Congressional Record, Volume 113, Part 12, June 13, 1967, page 15,645. The above undisputable record details the 14th Amendment's very reason to raise many issues in the United States courts, since the amendment was illegally ratified by military force, subduing all legislative Moors for the sole purpose of enduing their Republican government by way of universal Negro suffrage or political deprivation of their right to vote. All Southern states were against it, and therefore military coercion was necessary for the ratification of the amendment. Federal and state programs have utilized the 14th Amendment's illegal ratification to entrap as many Americans as possible into the District of Columbia's jurisdiction. The Social Security Administration requires the applicant to provide their race and ethnicity on question 6 and 7 of the SS5 form. Interesting enough, these two sections are the only sections the Social Security Administration advises the applicant that any information provided is voluntary. Section 6 asks the applicant to provide information on whether the applicant is Hispanic or Latino voluntarily. And Section 7 asks for race information. The applicant can select Native Hawaiian, Alaska Native, Asian American Indian, Black African American, other Pacific Islander, and white. This is another deceptive tactic to voluntarily have the applicant admit to be a franchisee of the 14th Amendment. There is only one race, the race of mankind, comprised of many nationalities upon the earth. Suppose the question was asked, where is the nation of white, Latino, or Asian? What would the answer be? That fact is, it doesn't exist. There is only Italian national, Californian national, Chinese national, Colombian national, Sudanese national, Irish national, etc. Section 5 of the application pertains to citizenship. The applicant can voluntarily select United States citizen, legal alien not allowed to work, or other. The obvious answer is other, per the instructions. Oh, fuck. Per the instructions, where was I at? Of SS5 form, the applicant must provide a document from the U.S. federal, state, or local government agency to support selecting others, which would be revealed. Under the GPO Style Manual 2016, Section 523, Nationalities, etc., the correct information that all Americans born in the national 50 states should provide on all applications requesting race or nationality. 523, in designating the natives of the state, the following forms will be used: Alabamian, Arizonian, Californian, Delawarean, Georgian, Hoosier, whatever that word is, Indiana, Illinoisian, Kansan, Louisianian, Marylander, Alaskan, Arkansan, Coloradan, Floridian, Hawaii resident, Idahoan, Iowan, Kentuckian, and as y'all can see, I'll let y'all look at those. I'm not going to go through them all. GPO Style Manual 2016, Section 523, Nationalities, etc. Page, oh gosh, etc. Page 95. The above nationalities are the actual native tribes of the Moors who inhabited the states under a republican government. The states are their own countries that form a confederation, which formed the United States of America in Congress assembled. The definition of a state is a nation or territory considered an organized political community under one government or concerned with a country's civil government. Oxford Dictionary. The information is the same on all other government agency applications. One's country is one's rightful nationality. However, if one voluntarily elects to classify themselves as a franchise of the 14th Amendment by identifying as black, white, Asian, Hispanic, etc., it would allow a true national also to be classified as a United States citizen, which is also on par of an enemy of the state, District of Columbia, per Trading with the Enemy Act of 1917. According to Title 50, War and National Defense, Chapter 53, Trading with the Enemy, the word enemy as used herein shall be deemed to mean for such trading and of this chapter. A. Any individual, partnership, or other body of individuals of any nationality resident within the territory, including the occupied by the military and naval forces of any nation with which the state with which the United States is at war, or resident outside the United States and doing business within such territory, and any corporation incorporated within such territory of any nation with which the United States is at war, or incorporated within any country other than the United States and doing business within such territory. B. Government of any nation with which the United States is at war, or any political or municipal subdivision thereof, or any officer, official, agent, or agency thereof. Such other individuals, C. Such other individuals or body or class of individuals as may be native, citizens, or subjects of any nation with which the United States is at war, other than citizens of the United States, wherever resident or wherever doing business as the President, if he shall find the safety of the United States or the successful prosecution of the war shall so require, may by proclamation include within the term enemy Title 50 U.S. Code 4302 A, B, and C. Part C just verified that the proclamation by the President, if in the best interest of the United States corporation located in the District of Columbia. The president may deem United States citizens to be an enemy of the state. U.S. Part C highlighted citizens of the United States with the phrase other than a citizen of the United States, which can be explained as you use other than after a negative statement to say that the person, item, or thing that follows is the only exception to the statement, pursuant to Collins Dictionary. Further evidence of the type of control the president has over people classification as U.S. citizens or on par with the enemy of the state can be read in Senate Report Number 93-594 of the 93rd Congress, First Session, titled Emergency Power Statuses, Provision of Federal Law, now in effect, delegating the executive extraordinary authority in time of national emergency. Number 19, 1973. Report of the Special Committee on the Determination of the National Emergency, United States Senate, forward. Since March 9th, 1933, the United States has been in a state of declared national emergency. There are now, oh goodness, there are now in effect 4 presidentially proclaimed states of national emergency. In addition to the national emergency declared by President Roosevelt in 1933, there is also the national emergency proclaimed by President Truman on December 16, 1950, during the Korean conflict, and the states of national emergency declared by President Nixon on March 23, 1970, and August 15 of 1971. These proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate the president extraordinary powers ordinarily exercised by the Congress, which affect American citizens' lives in a host of all-encompassing manners. This vast range of powers, taken together, confer enough authority to rule the country without reference to normal constitutional processes. Under the powers delegated by these state statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. Senate Report Number 93-549 of the 93rd Congress, First Session. Emergency Power Wars, November 19th, 1973, page 3. The President can control every aspect of the U.S. citizen, U.S. national resident, state citizen, and legal permanent resident or alien, and all forms of businesses registered under the Secretary of State, utilizing a license or permit. However, the Trading with the Enemy Act does not bind nationals of their respective countries. All right, so that concludes chapter 2, you all. I'm going to stop right there for today, and we'll continue this book um, more than likely tomorrow. Okay, and let me check the let me check y'all comments in the chat right quick. Okay. There goes that word again. Grand Rising. I'm glad seeing that. Please hit the like. Thank you, Mr. Somebody. Peace to you. Asia Lachey. Happy I finally caught a live reading. Glad you did too, Asia. Miss Vicky, wow, they were real clever in putting together this Constitution, especially exactly. Right. Aren't y'all surprised by what's being said? The 14th Amendment was a very racist set of set up part of the Constitution. Absolutely. Absolutely. So, with that being said, you all, I forgot to say that I reserve all my rights in the beginning of this video, and fair use for the reading of this book. Fair use, all rights reserved. I do not own the rights to the and titles to this book. It is for education and entertainment purposes only. So I want to thank y'all for being with me again today. I appreciate each and every one of y'all. Make sure y'all continue to like and share the content with your friends and family so that we can continue to wake our people up. Um, because the only reason why this stuff is still being able to happen to us with what's going on in the government is because our people are still asleep and need to wake up to this truth so that we can begin to do what we need to correct these wrongs that have been done over the last 100 or 2 years, 100 or 200 years. Okay. All right. So with that being said, I love you all. I appreciate you all again. Make sure you guys send donations if it is in your heart to do so. I gladly appreciate them. And again, y'all enjoy the rest of your day. Peace and love.